to the government seeking the service book for processing the payment of pension. Therefore, Mr. Angami prays for some time to take instructions as to whether the matter has been processed or not. I have also heard Mr.
I am alone.
Pray for the petitioner. The prayer, Mr. Angami, is allowed. List again on
28, Your Lordship.
28 this month.
I'm deeply obliged, my Lord.
For admission, item number 2.
Yeah, Joe, huh? Well. Yes.
May I please, Lordship? Lordship, I'm appearing for respondent number 6. I'm the private respondent and petitioner is challenging my appointment, Your Lordship. Lordship, in this, I have a short submission to make. Lordship, the state has filed an additional affidavit. If Your Lordship perused the additional affidavit filed by the state, Your Lordship, page number 7.
Yes.
Annexure F3. Lordship has got it.
Yes. Is it letter?
And the type copy is next page, Your Lordship. That would be,
Oh, yes.
Lordship, allow me to read the letter, Lordship. Subject is spot verification at Government High School, Yongyimson. In regard to the subject cited above and as per the direction on your letter such and such dated 5 October 2023. The undersigned along with 2 DBs, Dobashis of Customary Court, Changtongya went for a spot verification at GHS, Yongyimson on such and such and verified that the genuine owners of the land in which the school is located is Yashimaran and Noklan Nakshi. It is pertinent to know that the petitioner Sri Jongshinok is the son of Sri Yashimaran. However, as per the verification, the family of Yashimaran have not availed any facilities from the government. So, Your Lordship, if Your Lordship may take my affidavit in opposition, Your Lordship.
You are respondent number 1 to 5.
6, Your Lordship. Filed on 11/5/2023.
Yes.
Page number 11. That is related to the scheme for appointment on land ownership basis, Your Lordship. Page number 11 and 12 is a type copy. Lordship, I'll take the relevant, I'll just read the relevant part. That's 3B, next page.
Yes.
If there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim, including whether any employment or any facility, including contract or supply order, has been given in the past. So, Lordship, the letter which I have read earlier that relates only to facilities and not employment, Your Lordship. So my humble submission is, Lordship, if the state may be directed to take specific information regarding whether any appointment has been made, Your Lordship. In this regard, I would like to place one declaration made by the village council under whose jurisdiction the government high school is situated, Your Lordship. Mary, Your Lordship.
Yes.
This is to certify that Sri Jongshinok, that is the petitioner, is the biological son of Sri Yeshimaran. Sri Maung Tushi, who is the biological brother of Yeshimaran, that is the uncle of the petitioner, is presently serving as Chowkidar at GS Government High School, Yongyimson. So, Lordship, one of the family members has availed appointment, Your Lordship. So, if direction may be given to the government to take specific information, whether any employment has been availed.
By the family members of the landowner.
Lordship.
Please for the government.
Lordship.
Okay, you take instructions.
Yes, Lordship.
Heard the learned counsel MS,
Sigmo.
appearing for the petitioner. Heard the learned counsel Mr.
I Jamir.
appearing for the respondent number
6.
6. Also heard the learned government advocate
K. Angami, your lordship.
K. Angam. The state respondents are directed to ascertain as to whether any appointment in government service has been given to the family members of, who is the family member?
Family members of the petitioner, Your Lordship.
Family members of the petitioner.
Lordship.
After 2 weeks,
Lordship, in this case, after winter vacation, lordship.
after winter vacation.
Yes.
Okay, list immediately after winter vacation.
Lordship.
For admission, item number 4.
Lordship, on behalf of Imchen, Mo Imchen,
Yes.
he's yet to receive instruction. So kindly grant 3 weeks of time to file an affidavit.
The learned counsel, Mr.
Mo Imchen,
Moinchan, appearing for a state respondents.
the Lordship.
State respondents praised for some time to take instructions. The learned counsel, Mr.
And Kumar, my lord.
N. Kumar, has no objection. Therefore, the prayer of the state respondents is allowed,
After 3 weeks,
at
Lordship.
least after 3 weeks.
Lordship.
For admission, item number 8.
May it please your lordship.
Yes.
Lordship, kindly grant me 3 weeks time to file my affidavit in reply to the affidavit in opposition filed by the sole respondents.
The learned counsel, MS,
Vikonokisa.
appearing for the petitioner submits that she wants to file a reply in respect of the affidavit in opposition filed by the respondents. Therefore, the learned counsel prays for some time. I have also heard Mr.
K. Angami, lordship.
Shingan, and the learned counsel representing the state respondents. The prayer of the petitioner is allowed, list after 3 weeks.
Lordship.
For hearing, item number 10 to 11.
Yes.
May I please, Lordship? Lordship, in item number 9. Item number 10 and 11, Your Lordship. Except for the facts, Your Lordship, my legal submission will be common for both, Your Lordship. Now, Your Lordship, the petitioner, I'll take item 10 first, so far facts are concerned. The petitioner is aggrieved by the action of the respondent in advertising the post of Assistant Horticulture Specialist, AHS, Your Lordship, in Central Institute of Horticulture, CIS, at Metspema, Your Lordship, and which post is presently being held by the petitioner, Your Lordship. May I take Your Lordship to the advertisement? Advertisement is page 27.
Yes,
Lordship has got it.
yes.
This is advertisement number 5 of 2023, Your Lordship.
Mm.
And the post is at next page, page 28, serial number 3.
Yes,
Serial number 3, Your Lordship.
yes.
This is 2 vacancies for the post of Assistant Horticulture Specialist in CIS, Nagaland. And serial number 2 is the post Horticulture Specialist in respect of the next writ petition, item 10, Your Lordship. Now, the facts in brief, very facts, Your Lordship. May I take Your Lordship to page 17? The facts are very brief, Your Lordship.
Yes.
May I read out an actual? This is regarding engagement of 4 number of consultant technical for CIS Nagaland on contract basis for a period of 1 year with a consolidated payment of 20,000 month. Based on the approval of competent authority, applicants were invited for engagement of 3 consultant technical through advertisement in 3 leading newspapers in Northeast region and 2 national newspapers. We have received 11 applications, of which 7 eligible candidates were interviewed by a selection committee headed by such and such at Kohima. The other member of the selection committee are below. Now, third last paragraph from below. Based on the recommendation, Your Lordship has got it? Based on the recommendation of selection committee and on careful observation, it is proposed to engage following 4 number of candidates as consultant on contract basis. Name of the petitioner appear as serial number 3, Arvind Singh, Your Lordship. In this regard, we seek the approval of Secretary A and C, that is Agriculture and Cooperation, for engagement of above 4 number of candidates as consultant technical CIS Nagaland on contract basis for a period of 1 year on payment of a consolidated amount of 20,000 month to undertake various activities of the institute submitted for kind perusal and approval. Next page, Your Lordship, is the appointment order. This is dated 4th July 2007. I am to convey the approval of the competent authority in this department for engagement of Sri Arvind Singh as consultant technical on contract basis in the Central Institute of Horticulture, Medzuma, Nagaland on following terms. Period of engagement, 1 is 1 year. Remuneration, 20,000 per month, Your Lordship. Now, next page. So by this order, I have been appointed petitioner. Next page is the extension order. This is dated 13/10/2022. This is the last extension order. Though initially it was for a period of 1 month, 1 year. From subsequently it was extended from time to time, Your Lordship. And this is the last extension order. Though in the order it is said offer of appointment. I am to convey the approval of the competent authority in this department for extension of service of petitioner on technical consultant on contract basis. So by this, Your Lordship, this is the last extension order. Now, during this time, Your Lordship, I have submitted representation for extension. Lordship, this is page 20. This is the application for extension, Your Lordship. Now, Your Lordship. May I take Your Lordship to page 21? Page 21. The subject is proposal for engagement of 2 data such and such, but
Data entry operator.
data. And next, number 1, the detail of sanction post incumbency list. Your Lordship may kindly notice. This is the incumbency list. So in the incumbency list, Your Lordship, may I take Your Lordship to serial 5. Assistant Horticulture Specialist. Lordship has got it?
Yes.
Now, number of sanction post 3, and Mr. Arvind Singh. He is the petitioner, Your Lordship. In respect of this, the next writ petition, Your Lordship, that it relates to horticulture specialist. Mr. Anjani Kumar Singh is there. He is the petitioner in the second writ petition, Your Lordship. Now, Your Lordship, in the incumbency list, the petitioner, though Your Lordship, petitioner is appointed as consultant, but in the incumbency list is the list where the post is shown and the person who is appointed against that post is shown, Your Lordship. Now, as per the incumbency list, Your Lordship, the petitioner is shown as occupying the post of assistant horticulture specialist, Your Lordship. Now, number of sanctioned posts total, that is 17 is there. Your Lordship may kindly note this.
17 posts.
Total.
Here, the number of sanction posts.
Number of sanctioned posts below is 17. Lordship has got it? 17, 17. Lordship has got it?
Yes.
Yes. Now, may I take Your Lordship to page 23? Type copy is page 24.
Yes.
Now here, this is dated 7 December 2011. Subject is This is addressed to the director, such and such from the Ministry of Agriculture, Government of India. Subject is enhancement of remuneration in respect of A.K. Singh, who is the petitioner in the next writ petition, and Sri Arvind Singh, technical consultant, CIS, Nagaland, Your Lordship. Now, at that point in time, Your Lordship, even the petitioner in the second next writ petition was serving as consultant. But subsequently, he is now, through selection process, he was appointed as horticulture specialist, Your Lordship. Now, relevant paragraph, para 2, page 25.
Yes.
In view of the above position, it is clarified to CIS, Central Institute of Horticulture, Nagaland, that these two persons will be entitled to the enhanced rate of remuneration for the post of technical consultant, that is rupees 25,000 per month, as indicated in Ministry's order dated such and such, and would continue to be designated as technical consultant till their engagement in CIS or their adjustment against the post of specialist. Your Lordship, I'll be relying on this. Till their engagement in CIS or their adjustment against the post of horticulture specialist. This would also be subject to the condition that CIS Nagaland would not engage at any time personnel in excess of the sanctioned strength of 17%. That is why I've taken Your Lordship to that 17 post, and would keep 2 other posts vacant till this person continue to work as technical consultant, Your Lordship. Now, Your Lordship, my grievance is that without adjusting my post, I'm still continuing as consultant, though as per the incumbents list, I am shown as holding the post of assistant horticulture specialist, Your Lordship. Now, I'm still continuing to hold that post, but without adjusting my post, they have advertised the post, Your Lordship. Now, that is why I have approached this honorable court, Your Lordship. Now, may I take Your Lordship to the order dated 29/3/2023 passed by this honorable court, Your Lordship. The order passed, Your Lordship, that will be in separate sheet. The interim order has been passed, Your Lordship.
Order dated
29/3/2023. Lordship has got it.
Oh, yes.
Lordship. Now, towards the end, the operative portion. Having regard to the submission, Lordship has got it. Having regard to the submission made by the learner counsel for the petitioner, in the interim, it is provided that the respondent authority concerned shall not proceed with filling up of the one post of assistant horticulture specialist that was advertised through the impugned advertisement number 5 of 2023 without leave of this court. It is further provided herein that the petitioner is still continuing as consultant technical as on date, despite the contract period having been extended up to this. Status quo as on date should be maintained. So, Your Lordship, on the strength of this status interim order, Your Lordship, I'm still continuing, Your Lordship. Now, may I take Your Lordship to my pleading? Just 3 or 4 paragraphs, Lordship. Read petition, page 7, para 10.
Page 7.
Para 10. My read petition. Para 10. The petitioner respectfully stated, while considering enhancement of remuneration in respect of the petitioner and another technical consultant, the Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India, White Letter Number DCCs clarified to the Director of CS Management Nagaland as under. That second paragraph, which I have read out, Your Lordship. Now, may I take Your Lordship to para 12?
Yes.
That as the petitioner has been rendering continuous service for more than 16 years, now it is going to be 18 years, Your Lordship. Also, considering the fact that even the Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India has conveyed to the Director CS Matsivima that he will be adjusted against the post of horticulture specialist, the petitioner had legitimate expectation that he will be adjusted or absorbed in the service of CS Matsivima on regular basis. However, to the petitioner's utter shock and dismay, the UPSC published advertisement number such and such, inviting application for direct recruitment amongst others to fill up the vacancy number such and such, which is currently held by the petitioner. It may be mentioned here that the petitioner post is advertised under item 3 of the said advertisement, 5 of 2023, which I have taken your lordship to, your lordship. And your lordship, the fact that the post held by the petitioner has been advertised is not being disputed by the respondent, not being denied, your lordship. As per the advertisement 5 of 2023, for the said post of Assistant Horticulture Specialist, the age limit prescribed for the same is 35 years, your lordship. 13, your lordship. That as stated, the petitioner was appointed pursuant to advertisement which was duly published both in local and national paper and by a duly constituted selection committee. In other words, the petitioner was appointed after following a due process of recruitment and as per the constitutional scheme, except for the fact that the appointment was on contractual basis, your lordship. Now, as I've said, though the petitioner was appointed as consultant, your lordship, now as per the incumbency list, their own record, your lordship, petitioner is holding the post of assistant horticulture specialist. 14, that as the petitioner was appointed after following due selection process, the petitioner was under legitimate expectation, because this will be my alternative submission, secondly, on legitimate expectation, that his service will be adjusted, absorbed, regularized, and more so when even the Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India has also conveyed to the Director CIS that the engagement of petitioner in CIS will be adjusted against the post of horticulture specialist. Therefore, the action of the respondent in advertising the post of assistant horticulture specialist held by the petitioner before his adjustment against the post of horticulture specialist is highly unjustified, arbitrary, and illegal. As such, the UPSC response number 5 ought to be directed not to conduct the recruitment process for the said one post of assistant horticulture specialist pursuant to the said advertisement number this, till such time the post held by the petitioner is adjusted or absorbed against the post of horticulture specialist. 15, that the petitioner is now 54 years, now it's 55 years, your lordship, age, and as per advertisement, the age limit prescribed for the post of assistant horticulture specialist is 35 years. Being so, the petitioner is already overaged to apply for the said post of assistant horticulture specialist, your lordship. And your lordship may kindly pause, even going by the age, your lordship, petitioner has already rendered about 18 years of service, and going by the age, he has only about 5 years of service left for retirement on attaining the age of superannuation, your lordship. 16, that the petitioner has been rendering continuous service for more than, it will be 18 years now nearly. In the meantime, has already become overage, and there is no other employment opportunities available for the petitioner. Therefore, in the event the post of assistant horticulture specialist held by the petitioner is filled up, pursuant to the advertisement such and such, the petitioner will be left with no employment opportunities and thereby threatening even his right to livelihood. The last paragraph, your worship, 17. Therefore, that the petitioner submits that petitioner has been appointed against sanctioned post after undergoing, because why I'm saying sanctioned post, your lordship, because the post 17 posts the strength, your lordship, undergoing selection process as per the constitutional scheme. As the petitioner has been serving for more than now 18 years, nearly 18 years, the respondent ought to have considered his case for adjustment, absorption, regularization, as conveyed by Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India, to the Director CS Matsivima. However, instead of considering the representation for absorption, regularization, or adjusting against the post of horticulture specialist as conveyed by the Department of Agriculture and Cooperation, Ministry of Agriculture, Government of India, the respondent has issued the advertisement number this for filling up the post of assistant horticulture specialist. So, your lordship, my prayer is page 14. Page 14. Page 14A is to quash and set aside the advertisement for filling up vacancy number this as appearing in item number 3 of advertisement in respect of AHS in CIS Matsivima held by the petitioner. Second, Now direct the respondent not to advertise for filling up the post held by the petitioner till such time. This is my alternative. Prayer worship. Till such time the petitioner is adjusted, absorbed against the post of horticulture specialist in terms of the letter dated 7/11/2011 issued by the Department of Agriculture, Your Lordship. Now, Your Lordship, the respondent number 5, UPSC, has filed the counter affidavit. In the counter affidavit, they have stated that they have no say.
Yeah, they have no say, actually.
Lordship,
They have no say.
they have, that is what they have stated in the affidavit, Your Lordship, filed by respondent number 5. It is there, Your Lordship. At para 9, they've just said they have no role to play. Now, coming to the affidavit filed by respondent number 1 to 4, there is the union, the main respondent, Your Lordship. I'll just read out 3-4 paragraphs, Your Lordship. Para 3, page 2.
Yes.
That the CIS Matsefima Dimapur Nagaland was established on 16 January 2006 with cabinet approval. Initially, it was proposed to engage consultant technical on monthly basis for a period of 1 year to take up various development activities of the institute till the appointment of regular staff. With the approval of the ministry after conducting interview by the temporary committee members, 4 number of candidates were engaged as consultant in CIS Nagaland in 2007 on contract basis for a period of 1 year on payment of a consolidated amount of rupees 20,000, which is renewed from time to time for every 6 months. In the meantime, 17 posts were sanctioned by the Department of Expenditure, Ministry of Finance, via their ID note dated 23/6/2006, Lordship, to be filled up on deputation. Now here, Lordship may kindly, for a moment, may turn to page 13. Page 13 is the letter. Just for a moment, Your Lordship.
Yes.
Para 2, at the bottom, para 2.
Yes.
It is, however, stipulated instead of going for deputation or direct recruitment, all posts may be filled up by deputation / redeployment basis. And bottom, Your Lordship, the date is given 23/6/2006, Your Lordship. Now, as early as in the month of June 2006, the post was already created. Sanction post was already there. Now, my appointment was in the year 2007, after more than a year after creation of the sanction post. It is not prior to the creation of the sanction post, Your Lordship. So when I was appointed as consultant on contract basis, the sanction post, 17 post was already there. It was already there, Your Lordship. And coming back to the statement made, to be filled up on deputation, but it is not on to be filled up. It may be filled up on deputation. That is the word used, Your Lordship. Redeployment basis to obtain regular permanent staff of CIS Nagaland. Accordingly, recruitment rules RR for 17 posts of CIS were notified, and after making several attempts, no post except the post of director could be filled up as per RR. Since then, from 2009, these posts were also been filled up on contractual basis for a period of every 6 months for running CIS Nagaland against the sanctioned 16 posts. Sanctioned 16 posts means that is excluding the post of director. However, Department of Expenditure, Ministry of Finance, by such and such, dated such and such, agreed to revive the 16 posts of CIS Nagaland subject to the condition that these posts were filled up on regular basis as per prescribed RR only. Accordingly, RR of recruitment rules of all the 16 posts were notified with inclusion of direct recruitment method to recruit the regular permanent staff of CIS Nagaland. Now, here also, Your Lordship, there's a misrepresentation because even the RR provides for recruitment on deputation, including short-term contract. I'll take Your Lordship to the rules RR. Thus, as per the direction of Department of Agriculture, UPSC and Staff Selection Commission have been approached to fill up this post on direct recruit basis as per the amended RRs and advertisement number under item for 2 vacancies post of assistant such and such was published by UPSC to recruit regular staff in CIS Nagaland as per recruitment rules. Para 6, Your Lordship. Next page. I'll just read out the relevant paragraph, Your Lordship. In fact, my taking Your Lordship to the affidavit will save time because he will not. That with regards to the statement made in para 9, it is submitted that the petitioner was engaged as technical consultant on contract basis by the offer of appointment number this. The letter number dated this referred by the petitioner does not reflect the petitioner is working as assistant horticulture specialist. This annexure 7, Your Lordship, is that incumbency list, Your Lordship. Now, para 7. That with regards to the statement made in para 10, it is submitted that petitioner has misunderstood this ministry order number this and his claim that his service will be absorbed regularized against the post of horticulture specialist is not justified as the appointment of the petitioner was purely on contract basis, but ministry's order number this, nature 4, contractual service of the petitioner has been extended for every 6 months from time to time as per the terms and conditions of the agreement, which has been accepted by the petitioner also. Thus, the petitioner is aware of the consequence of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post when an appointment to the post could be made only by following proper procedure for selection. As per the offer of appointment, number such and such, contract appointment shall not confer any right for regularization or absorption in the post. 8. That the petitioner has continued to work as technical consultant on contract basis since his initial appointment in 2007, and he has never worked as assistant horticulture specialist in Nagaland. However, as per ministry's order number this, the petitioner continued as technical consultant till his engagement in CIS Nagaland or his adjustment against the post of horticulture specialist. In this regard, it is submitted that as per para 1 of the order dated 7/12/2011, it was meant for the post of assistant horticulture specialist only and not for horticulture specialist. But what about para 2? I have taken Your Lordship to para 2 of that ministry's order. With regards to other observation that CIS Nagaland would keep 2 other posts vacant till these 2 persons continue to work as technical consultant, it is submitted that this was meant only for contractual employment as per the contractual agreement accepted by the petitioner and not for absorption, regularization of the petitioner to the post of assistant horticulture specialist as the method of appointment available in the RR's was deputation, including short-term contract, this is their own statement, and was not available as absorption or direct recruit. Further, in support of his contention, various decisions of Honorable Supreme Court may be relied upon, and amongst them, one being rendered in Secretary, State of Karnataka versus Uma Devi, the Honorable Supreme Court held that is para 47, Your Lordship. Now, last paragraph. That with 9, para 9, last. That with regards to the statement made in para 11, it is submitted that the recruitment rules of the post of CIS Nagaland do not provide the absorption regularization of contractual staff, as regular staff is recruited by following a proper procedure for selection through UPSC only, Your Lordship. Now, I filed a reply to this. Your Lordship, may I take Your Lordship only to 3 paragraphs to my reply?
Yes.
Para 7, 8, and 9, Your Lordship. Just short, just one. Page 4. That the statement made in para 6 of the affidavit in opposition, the deponent reiterates and reaffirms the statement made in para 9 of the writ petition. It is further stated in the letter dated 27/11/2023, and which is also relied upon by the respondent themselves, wherein the detail of sanction post incumbency list is provided. The name of the deponent is entered as serial number 5 and shown as assistant horticulture specialist. Therefore, it is too late for the respondent authorities to deny the fact that the post of technical consultant held by the deponent is equivalent to the post of assistant horticulture specialist. 8. that with regards to the statement made in para 7 and 9 of the affidavit in opposition, the deponent reiterates and reaffirms the statement made in paragraph 9, 10, 11, 13, 14, 17, and 18 of the writ petition. It is reiterated that the deponent was appointed pursuant to advertisement, which was duly published both in local and national paper and by a duly constituted selection committee after following due process of recruitment. In other words, the deponent has been appointed after following due process of recruitment and as per the constitutional scheme. Having appointed through a regular selection process, the deponent had legitimate expectation that his service will be adjusted by way of regularization or otherwise, as conveyed to the Director CS Matsafima by the Ministry of Agriculture, Government of India. The deponent states that the word adjusted cannot be construed as advertisement. Furthermore, the respondent number 1 to 4 have not denied that 2 posts should remain vacant until the petitioner is adjusted against the post of horticulture specialist. Therefore, the action of the respondent in advertising the post before his adjustment as horticulture specialist is highly unjustified, arbitrary, and illegal. Last paragraph, 9. That with regards to the statement made in para 8 of the affidavit in opposition, the deponent reiterates and refutes the statement made in para 7 and 8 of the affidavit. It is further stated that the decision relied upon by the respondent as rendered in Secretary State of Karnataka versus Uma Devi is not applicable as the deponent has been appointed through a regular proper selection process as per constitutional scheme. Uma Devi is a case, Your Lordship, where those are backdoor appointment with a appointment made without advertisement. So this case is distinguishable, Your Lordship. Now, my submission, Your Lordship, my legal submission will be very short, Your Lordship. Now, as per the incumbency list, which I've taken Your Lordship to, Your Lordship, the petitioner, admittedly, he is appointed as consultant, technical, Your Lordship. But as per the list, he is shown as holding the post of assistant horticulture specialist. And the fact that the post held by the petitioner is being advertised. Advertisement is not consultant, Your Lordship. The post is assistant horticulture specialist, and the stand of the petitioner is that the post held by the petitioner has been advertised. That is not been specifically denied by the respondent, Your Lordship. Now, the ground taken by the respondent on the ground, because the respondent has referred to recruitment rules, Your Lordship, that there is no provision under the recruitment rules for absorption of contract employees, Your Lordship. Now, may I take Your Lordship to the rule, Your Lordship, the affidavit in opposition of the union, Your Lordship. Page 30.
Page 30.
It starts from page 29. There's a Hindi version is there. Page 30, that is the English version. Page 30, Your Lordship has got it.
Yes.
Lordship may kindly see section 1, short title and commencement. Lordship has got it?
Yes.
Yes.
Gazette notification.
These rules may be called the Ministry of Agriculture and Farmers Welfare such and such. In specific,
Yeah, just a minute.
page 30,
29 is Hindi.
30. Page 29, it starts from page 29, Gazette. That is in Hindi version.
Oh, yes.
So page 30, 30, short title and commencement, section 1.
1, yes.
Yes. Short title and commencement. These rules may be called the Ministry of such and such Welfare Department for, this is for Assistant Horticulture Specialist. Recruitment Rules 2022, Your Lordship. Now, coming to the schedule, a table is given.
Yes.
Number 1, name of post is shown, Assistant Horticulture Specialist. Lordship has got it. Now, the relevant page, page 32.
Yes.
Page 32, column 10. On the right side,
Yes. 67%.
page 32, column 10. On the right side, extreme right, method of recruitment is there. Lordship has got it.
Yes.
Now, whether by direct recruitment or by promotion or by deputation or absorption, such and such, Your Lordship made this 67% by direct recruitment, 33% by promotion, failing which by deputation, including short-term contract. So deputation, so short-term contract is also included, Your Lordship. So in my respectful submission, the R clearly provides, Your Lordship, for absorption of short-term contract employees. So the statement made by the respondent that there is no provision in the RR for absorption of short-term contract employees, Your Lordship, that is, my respectful submission is not correct, Your Lordship. Now, second submission, Your Lordship, the legal objection which has been taken is on Uma Devi, Your Lordship. Now, in case, Your Lordship, in where appointment is made through a regular selection process, Uma Devi is not applicable. So this is the case. The first case, Binod Kumar versus the Union of India, Your Lordship. Now, relevant para 3.
Yes.
May I read out? Pursuant to notification dated this, the applicants were initially appointed to ex-cadre post of accounts clerk after a selection process involving written test and viva voce interview. After the rejection of the representation for regularization to the divisional railway manager in 1999, the appellants approached the Central Administrative Tribunal by way of OA. The tribunal by order dated such and such dismissed the application of the appellant, concluding that the appointments were temporary and for a specific scheme, thus not entitling them to regularization or absorption into permanent posts. Thereafter, the appellants approached the High Court and the High Court upheld the order of the tribunal and dismissed the writ petition, observing that the appellants' employment under a temporary scheme could not confer upon them the right akin to those held by permanent employees and relied upon the judgment of this court in Uma Devi, which held that temporary or casual employees do not have a fundamental right to be absorbed into the service. 4. The appellants have approached this court arguing that the High Court erred in its judgment by failing to recognize the substantive nature of their duties which align with regular employment rather than the temporary or scheme-based rules they were originally appointed for. Further, their promotion for a regularly constituted promotional committee, the selection process they underwent, and the continuous nature of their service for over a quarter of a century underscored their argument for regularization, and that the High Court has incorrectly applied the principle from the case of Uma Devi to their situation, Your Lordship. Now, 5. Having heard the arguments of both sides, this court believes that the essence of employment and the rights thereof cannot be merely determined by the initial terms of appointment. When the actual course of employment has evolved significantly over time, the continuous service of the appellant in the capacity of regular employees performing duties indistinguishable from those in permanent posts, and the selection through a process that mirrors that of regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Para 6, Your Lordship. The application of the judgment in Uma Devi by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and a subsequent circular followed by a selection process involving written tests and interviews, which distinguishes their case from their appointment through backdoor entry as discussed in the case of Uma Devi. Uma Devi was backdoor entry, Your Lordship. Now, may I take your Lord, para 8, Your Lordship. In the light of the reason recorded above, this court finds merit in the appellant's argument and holds that their service condition as evolved over time warrants a reclassification from temporary to regular status. The failure to recognize the substantive nature of the rules and their continuous service akin to permanent employees run counter to the principle of equity, fairness, and the intent behind employment regulation. Accordingly, this appeal was here, Your Lordship, the substance is, Your Lordship. If appointment is made through a regular selection process by way of advertisement, and this is a case I have taken Your Lordship to the records where advertisement was made both in local and national newspaper, Your Lordship. So, Your Lordship, in the case in hand, Your Lordship, Uma Devi does not apply. Now, Your Lordship, just to counter the argument, the submission made that in RR there is no provision for absorption of short-term contract. That is not. That Uma Devi they relied. I said, no, Uma Devi does not apply. Now, grounds for seeking relief, Your Lordship. Firstly, Your Lordship, I repeat at the cost of repetition, though petitioner was appointed as consultant, Your Lordship. Now, for all purpose, even in the incumbency list, he has been shown to be holding the post of assistant horticulture specialist, Your Lordship. Now, and the post was already there. The sanctioned post was already there when the petitioner was appointed. It is not the case that the post, 17 sanctioned post was created after petitioners were appointed, Your Lordship. When the sanctioned post was already there, like why after making the petitioner go through interview everything, appoint him on contract basis? That is also as consultant, which post is not there, but he is shown as assistant horticulture specialist, Your Lordship. Therefore, Your Lordship, taking into consideration the manner in which the petitioner has appointed, Your Lordship, my respectful submission, this is a case where, Your Lordship, the respondent ought to be directed to regularize the service of the petitioner, Your Lordship. Now, in the similar matter, Your Lordship, has been dealt with by Honorable Manipur High Court. I would like to rely on that, Your Lordship. That is number 2. I have flagged, Your Lordship. This writ petition 519 of 2018, Your Lordship. May I take Your Lordship to para 3.1. 3.1, Your Lordship has got it?
Yes.
Facts and circumstances as narrated in the writ petition are that the Manipur Technical University, here referred to as the university, came to be established pursuant to the promulgation of an ordinance called such and such. And in order to make the university functional, the registrar issued a notification, this is an advertisement, Your Lordship, for appointment to the post of assistant professor on contract basis in respect of some subject including humanities such and such. The petitioner being eligible applied for appointment to the post of assistant professor, and after the interview having been held, the selection committee recommended the names of the petitioner for appointment to the post of assistant professor against the post shown as against their names. On the basis of the said recommendation, the petitioners were appointed on contract basis by order dated such and such, issued by the VC, and their contractual appointment were extended for 6 months or till regular appointees join the said post. Para 3.3. Next page, Your Lordship. To the petitioner's utter surprise and dismay, the university notified for fresh recruitment. Just like this, first advert, again, second, fresh of all the posts of the university by notification dated this, and being agreed by it, the instant writ petition has been filed by the petitioner on the inter alia grounds that since the petitions have been appointed after following the due procedure, their appointment was within the ambit, province, and scope of provision of Article 16 of the Constitution of India, that in terms of the law laid down by the Honorable Supreme Court, the petitioner ought to have been provided with orders of regular appointment, and that the initial period of 2 years ought to have been treated as probation. Now, 4. An affidavit in opposition on behalf of the respondent university has been filed, wherein it has been stated the selection was done only by interview, but was not done in consonance with the procedure for regular appointment, and the engagement of the petitioner was done for a short period in order to start the university, Your Lordship. Now, page 6, para 6, next page. Relying upon various decisions of the Honorable Supreme Court, three such and such, the learned counsel appearing for some of the petitioners had made submission, one of which being that since the petitioners had been appointed after following due procedure, their appointment was within the ambit, province, and scope of the provision of Article 16 of the Constitution, my submission also. And therefore, in terms of the law laid down by the Honorable Supreme Court, the petitioner ought to have been provided with orders of regular appointment, and the initial period of 2 years ought to have been treated as probation. In support of his contention, he has placed reliance on the decision of the Honorable Supreme Court in such and such. To Article 16, which finds place in Part 3 of the Constitution relating to fundamental rights, provided there shall be equality of opportunity for all citizens in matter relating to employment or appointment to any office under the state. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in public offices. The word employment or appointment covers not only the initial appointment, but also other attributes of service like promotion and age of coronation, etc. The appointment to any post under the state can only be made after a proper advertisement has been made, inviting application from eligible candidates and holding of selection by a body of expert or a specially constituted committee whose members are fair and impartial through a written examination or interview or some other rational criteria for judging the intrinsic merit of candidates who have applied in response to the advertisement made. A regular appointment to a post under the state or union cannot be made without issuing advertisement in the prescribed manner, which may in some cases include inviting application from the employment exchange where eligible candidates get their names registered. Any regular appointment made on a post under the state or union without issuing advertisement, inviting application from eligible candidates, and without holding a proper selection where all eligible candidates get a fair chance to compete would violate the guarantee enshrined under Article 16 of the Constitution. Now, Your Worship, page 10. I'll just read out the last paragraph starting with fifthly. Fifthly, it has also been submitted that at the time of advertisement issued by the university, regular vacancies were available, Your Lordship. The sanctioned post was available. The UGC Regulation 2010 were already in operation, and the university could have initiated recruitment process for appointment on regular basis, which the university failed to do so, and therefore, the petitioner should not be allowed to suffer for no fault of theirs. He has relied on the decision in Salini versus such and such, wherein the Honorable Supreme Court, accepting the contention of the learned counsel, appearing for the appellant, that the appellant should not be made to suffer for no fault of hers, directed the appellant shall be treated as a regular student of BSc such and such forthwith. A similar view was also taken by the Honorable Supreme Court in such and such. Now, page 12, para 7. On the other hand, it has been submitted by Sri such and such senior advocate appearing for Respondent University that the appointment of petitioner was purely on contract basis, and as per the terms and condition of the agreement and the undertaking given by them, they cannot claim for regular appointment at all. In support of his contention, he has relied upon various decisions of the Honorable Supreme Court, the first decision being one rendered in this thing, Omar Devi, Your Lordship. Now, page 16, Lordship, may kindly come to page 16. Para 8.
Yes.
It is not in dispute that the university was established by notification dated this for the advancement and development of technical education and for connected matters. The registrar of the university issued notification dated this for contract engagement in respect of various subjects, and in response thereto, the petitioner applied for it, and after the interviews being conducted, the selection committee recommended the names of the petitioner who were appointed on contract basis. Now, coming to the last fifth line from bottom. On 23/5/2018, Lordship has got it?
Yes.
The university issued a notice inviting application, this advertisement, from amongst the eligible persons for appointment to various posts, teaching and non-teaching, including the post held by the petitioner. This notice dated 23/5/2018 is under challenge in this writ petition. Para 9, next page. The question, having regard to the facts and circumstances of the present case, is as to whether the petitioners are entitled for regular appointment. In order to decide this main issue, this court will be required to examine the ancillary issue. The first ancillary issue is as to whether the recruitment process has been done by conforming to the provision of Article 16 of the Constitution of India. The answer ought to be in the affirmative for the reason that while undertaking the selection process, the same was done in accordance with the provision of Article 16 of the Constitution of India, which provides for equal opportunity and employment, in the sense that the advertisement was issued inviting application from amongst the eligible candidates, that the interview was held by a selection committee, and only on its recommendation, the petitioners were appointed by the university. The second ancillary issue is as to whether the appointment was purely on contract basis, and since the petitioner having given undertaking that they will not claim any regularization, the writ petition is liable to be dismissed. It is an undeniable fact that appointments were purely on contractual basis, as is evident from the advertisement itself, and the appointment order issued by the university, and moreover, the petitioner have given the said undertaking. But the contention of the learner council appearing for the petitioner is that it was a mistake on the part of the university that when it did not initiate the recruitment process for appointment on regular basis, and therefore it cannot take advantage of it. His submission has merit and substance. The clear vacancies were admittedly available at the time when the advertisement was issued by the university, and as per the ACTA norms, 80% of the posts ought to have been filled up on regular basis, which the university failed to do so. However, the learner council appearing for the responding university has heavily relied upon the decision rendered by the Honorable Supreme Court in Umadevi to contend that the petitions are not entitled to be regularized at all. It is no doubt true. The Honorable Supreme Court has laid down the law as regards the constitutional mandate in matters relating to public employment, including the appointment on contract basis. But the decision in Umadevi case will have no application at all to the facts of the present case for the reason that the Honorable Supreme Court has held in respect of contract appointment is that if the contract appointment has been made without following due process of law, they're entitled to be reviewed. This is not so in the present case because due process of law has really been followed even in this case. And there are many instances where the appointment on contract basis after following due process of law have been regularized by way of policy deviation. Page 21, Your Lordship. Just 11 portion. 6th line from bottom.
Yes.
The learner council appearing for the petitioner have submitted that in terms of the decision rendered by the Honorable Supreme Court in such and such, a direction ought to be issued to provide the petitioner with order of regular appointment from the date of the initial appointment. The fact of that case are not actually the same as that of the present case. Now, 3rd line from bottom. In the present case, it is not in dispute that at the time when the advertisement was issued, the vacant posts were available and the university could have initiated the recruitment process for appointment on a regular basis, but it failed to do so for reasons best known to it. The recruitment process remained almost the same except determination of score on academic records. Moreover, since the UGC Regulation 2010 were in operation, the university could have done the recruitment process in accordance with the said regulation if it really wished to do it. Failure to do so by the university in accordance with UGC Regulation 2010 was due to its fault and cannot be attributed to the petitioner, since the petitioner has already been subject to the recruitment process. Without the said being questioned by anyone, there is no need for them to undergo another such recruitment process. But in this present case, Your Lordship, even if I want to undergo the recruitment case, Your Lordship, I am on the verge of my retirement. I cannot, Your Lordship. In the peculiar facts and circumstances of the present case, this court is of the view that the petitioner cannot be denied appointment on a regular basis for no fault of theirs, and that too after they're subjected to a long process of recruitment. In view of the above, such and such, the advertisement was quashed and set aside, Your Lordship. Now, Your Lordship, I'm adopting the same submission here, Your Lordship. Now, when the petition is appointed by a competent authority after regular selection process as per constitutional mandate, Your Lordship. Now, this is a case where, Lordship, the respondent ought to be directed at least to regularize the service of the petitioner, Your Lordship. That is my first limb of submission. My second limb, Your Lordship, is on legitimate expectation, Your Lordship, my alternative prayer. Now, in this case, Your Lordship, the respondent has given legitimate expectation to the petitioner, both by words and also by conduct, that his service will be regularized or that he will be adjusted against the post of horticulture specialist, Your Lordship. Now, I've already taken Your Lordship to the ministry's letter, where especially it is meant that till I am adjusted against the post of horticulture specialist. Now, that is by word, Your Lordship. And why I say that expectation was given even by way of the conduct, Your Lordship. As per the recruitment rules, contractual employees' appointment cannot exceed beyond 3 years. I've been serving for nearly 18 years, Your Lordship. So by their conduct, may I take Your Lordship to the RR, affidavit in opposition. Page 41. Page 40, Your Lordship, this is the Hindi version. Page 41 is English version, Your Lordship.
Yes.
The first recruitment rules which I've taken, Your Lordship, that is recruitment rules of 2022. Now, this is recruitment rules. This is 2007, Your Lordship. So this was in force till 2022 came into effect. The first rule which I've taken is page 30, Your Lordship. That is recruitment rules of 2022. Page 30, that English version.
Yes.
Huh? 5 minutes.
Yes.
So this is 2022 rules and page 41, Your Lordship. This is 2007 rules.
Is 41.
Page 41.
Yes.
Page 40, that is the Gazette, Hindi, that version is there. Page 41, Your Lordship. Now, page 43, relevant portion, I'll take. And this relates to the post of Assistant Horticulture Specialist. May I take Your Lordship to page 42, the last table, bottom table.
Assistant horticulture specialist.
Yes. Now, page 43. Just above in the center, period of deputation, including short-term contract. Lordship has got it. Period of deputation,
Including short-term contract.
including short-term contract. Period of includes in another as cadre immediately preceding the appointment of some orders shall ordinarily not exceed 3 years. I am on this, Your Lordship. So short-term contract, or in other words, contractual appointments, short-term, it should not exceed 3 years. Now, in my case, as I said, I am continuing for nearly 18 years now, Your Lordship. So by extending my contract service from time to time beyond the limit prescribed in the recruitment rules, Your Lordship. Now, a legitimate expectation has been given to me that I'll be regularized, or at least my post I'll be adjusted against the post of horticulture specialist in terms of the ministry's letter, Your Lordship. Now, after giving that legitimate expectation to the petitioner, Your Lordship, advertising the post held by me without adjusting, Your Lordship, that is unfair and unjust on the part of the respondent, Your Lordship. Therefore, Your Lordship, that on legitimate expectation, Your Lordship, may I take Your Lordship to case number 3.
Page number 3 of what?
Case number 3, Your Lordship, of my compilation. Case number 3. My compilation case law. 1998 7 SCC. I flagged it, Your Lordship. 3 is there.
Yes.
Lordship. Para 18 to 23. These are short paragraphs, but I'll read only para 18 and 23.
Yes, 18.
The doctrine of legitimate expectation has its genesis in the field of administrative law. The government and its department in administering the affairs of the country are expected to honor their statement of policy or intention to treat the citizen with full personal consideration without any iota of abuse of discretion. The policy statements cannot be disregarded unfairly or applied selectively. Unfairness in the form of unreasonableness is akin to a violation of natural justice. It was in this context that the doctrine of legitimate expectation was evolved, which has today become a source of substantive as well as procedural right. But claim based on legitimate expectation have been held to require reliance on representation. A representation has been made to me, Your Lordship, both by word and by conduct, and resulting detriment to the claimant, and in the same way as claim based on promissory estoppel. Para 23, Your Lordship, just 11 paragraphs. Next page. Para 23. This court further observed as under. The existence of legitimate expectation may have a number of different consequences, and one of such consequences is that the authority ought not to act to defeat the legitimate expectation without some overriding reason of public policy to justify its doing so. In the case of legitimate expectation, if the authority proposes to defeat a person's legitimate expectation, it should afford him an opportunity to make a representation in this manner, Your Lordship. No, I've not been given that opportunity also. It may be indicated here that the doctrine of legitimate expectation imposes, in essence, a duty of public authority to act fairly, taking into consideration all relevant factors relating to such legitimate expectation. Within the conspectus of fair dealing in case of legitimate expectation, the reasonable opportunities to make representation by the parties likely to be affected by any change of consistent past policy come in, Your Lordship. Now, next, case law 4, Your Lordship. I will be just concluding, Your Lordship, not much. On legitimate expectation, para 29.
Yes.
A person is said to have a reasonable or legitimate expectation if a representation or a promise made by an authority, either expressly or impliedly, that is by conduct, Lordship, gives room for such expectation in the normal course. While applying the doctrine of legitimate expectation, the primary consideration and reasonableness and fairness is, the primary consideration is reasonableness and fairness of the state action. In my response, I say that the action of the respondent in advertising the post after giving me legitimate expectation that I will be adjusted against the post of horticulture specialist, Your Lordship, that is very unreasonable and unfair, Your Lordship. Now, Your Lordship, now my second limb of submission or alternative prayer, Your Lordship. Now, since after giving the legitimate expectation, Your Lordship, now the petitioner, in that hope that he will be absorbed or that his post will be adjusted against the post of horticulture specialist, Your Lordship. Now, he's been serving for 18 years, Your Lordship. And now, as I've said, going by the age, he has only about 5 years of service left for retirement on attaining the age of superannuation, Your Lordship. Now, even if I cannot be directed to be regularized. Respondent cannot be directed to regularize my service against a post of horticulture specialist, Your Lordship. At least, and if it is the case of the respondent that the post is advertised is not the post held by me, then at least I may be allowed to continue to serve another 5 years, Your Lordship, as consultant, till such time my post is adjusted against the post of horticulture specialist, Your Lordship. That is my alternative, second limb of my submission, Your Lordship. Now, Your Lordship, I have relied on a decision passed by Honorable High Court of Manipur, Your Lordship. So on that, my fifth case law, Your Lordship, last, like on judgment passed by another High Court, Your Lordship. I will just refer to para 23.
Yes.
Para 20, the three last line. Just the judgment of the other High Court, Your Lordship has got it.
Yes.
Though not binding, have persuasive value, we should be taken note of and dissented from such. At least it has got persuasive value. And Your Lordship may kindly also take into consideration the fact that the judgment passed by the Honorable Manipur High Court is by relying on the decision passed by the Honorable Supreme Court, Your Lordship. Now, in fact, except for the facts, Your Lordship, little different, but my legal submission in respect of the secondary petition are the same, Your Lordship. But in that case, he has been already, again, another advertisement was made. He has appeared for interview for the post of horticulture specialist, and he is now holding the post of assistant horticulture specialist. But his post also has been advertised. Now, this is a case where he is already holding the post. Since he is already holding the post of horticulture specialist, Your Lordship, and that also after a true regular selection process. at least direction can be given to regularize him, Your Lordship. That is the case, Your Lordship.
Lordship,
My obligation.
just now I've been informed by the register that you'll be leaving by 12. So if I take time, it will, so we can give it.
We can
Butler,
continue
Lordship,
next
Lordship,
week.
we can continue because there's only two cases, not one case, two cases there. So
Next Tuesday.
anytime, Lordship, yes.
Urgent on Council Mr. TB Jamil, preparing for the petition.
Lordship, sorry, on Tuesday, I have a fixed case in court number 2.
Monday,
On Monday,
As part of.
as part of
yes, Lordship.
preparing for the petition. List on 25 probably. Next Monday will be what is the date? 25. List on 25 as
Monday.
part hard.
Yes, Lordship. As first item, Lordship,
As
but
item,
first as far as,
as item number 1.
yes, Lordship. Much obliged.
Much obliged, Lordship. Much.
Okay. Item number 12, you're right. Release this matter on 26. No, 11 November.
Which item?
Okay.
Much obliged.
Much.
Aku ni biar malas ini Petitioner. Next, tahu ke? Baik, kamu jago tahu. Kalau sampai sini tak kamu jago tahu. Itu mah diri deh. Kalau di lalu kue kena itu sih kami kubur. Terus baik kamu jago tahu. Ya,
Nah, itu habis case dulu.
nah, kes kalau dulu ada tahu.
Case dulu kena saya. Itu besar semua. CGS Central Government Sending Council. Why? CGC. I don't know where. I don't know. One thing that we still